The Electricity Amendment Bill is currently in the public hearing phase. If passed, it will see Eskom being separated into 3 companies, one of which will be for transmission. The National Energy Regulator is hopeful that the bill will finally resolve electricity distribution problems. For more on this, we're joined by Nersa's Nhlanhla Gumede. Kwaba, good to have you, and thank you very much for your time. For the benefit of those who might not understand what makes up the grid is made up of 3 building blocks, so as to say. Generation, which is the power plants. We've got 58 gigawatts worth that is coming out of there. We've got then the transmission grid, which I'm told is about 28,000 kilometers of high voltage lines. And then we've got the distribution component, which is 325,000 kilometers of lower voltage lines, which certainly would include some of the infrastructure that the municipalities are taking care of. Now, where you come in, you, up until this point, have been licensing about, 170 or more municipalities to be the distributors of electricity. How does this amendment change that particular structure?
Good afternoon, or good evening to you and the viewers of. But the challenge is that it doesn't. What I was saying, I think it may have been quoted out of context. That's what I was saying was that the bill talks a little bit. It focuses a lot on the creation of a liberalized market, especially for the generators. And then, of course, it does kind of foresee possibilities of a market into the future. However, that market is still about the so-called discos or the distributors who will then be buying power from the generators. Now, unfortunately in South Africa, because of our constitution, municipalities have got the right to reticulate, and therefore, whatever number of municipalities that we have would all individually have a right to actually buy power or to participate in that market. So that's what the point is I was trying to raise. All I was saying is that it is an elephant in the room because that needs to be sorted out.
It has been an elephant in the room for a while. I'm sure you're well aware. The white paper sought to bring some kind of relief to this, called the Regional Electricity Distribution, or REDs. But negotiations went on for 10 years, I think, and nothing was ever resolved on that, and therefore we don't have these things called REDs, as you put it. The duty to reticulate still sits pretty much with municipalities, and it was thought that if we bring in REDs, they will then be able to come up with what is called a cost-reflective tariff, which creates a whole lot of turmoil, especially in poor communities, because you've got Eskom charging a particular price, and in some instances you've got people like City Power charging another different price, and they are all supplying to the same community. Why has this been such a struggle to resolve?
Well, the issue of the REDs, as they were called, the regional distributors, unfortunately that issue is a constitutional issue. However, the question that you are raising is a different story, because even in respect of the existing Electricity Regulation Act, the Act envisages that you'll have generators and a transmitter, and then you'll have these distributors. But in respect of the Act, and of course, you then have traders. But as far as the Act is concerned, it does not necessarily distinguish between Eskom as a distributor and the municipalities being a distributor. So ideally, we should still be able to work within the existing Act to actually sort out a number of these distribution challenges. However, it would have been better dealt with if the idea of consolidating distributors into 6 regional companies or into the 6 regional distributors, as it is done, by the way, next door in Namibia. They set themselves a goal of creating 5. They created 3. They've got 2 remaining. But in our case, unfortunately, the parties couldn't find themselves, because the parties in this particular case are basically local government, because there are powers that are dedicated to local government in terms of our constitution, and of course national government, to then say, can we find a sweet spot where the consumers would benefit, but at the same time municipalities would be able to then exercise the powers that are given to them by the constitution, which is to reticulate electricity to the consumers.
And now, the electricity minister says the 325,000 kilometers or so of distribution line is not in good shape. And he says this is largely because of underinvestment by the very same municipalities from 2011 right up until 2022, accumulating an amount of about 30 billion that they still need to put in there as far as the maintenance of infrastructure is concerned. What are the conditions that Nersa attaches when they issue the license?
Let's put it this way. Because Nersa approves a tariff for distribution, part of that tariff, for instance, is meant to cover maintenance. It's also meant to cover the investments that need to be made in the distribution network, as well as supposed to cover for all of the other operating costs that are associated with distribution as a part of a value chain. However, what actually happened is that the Electricity Regulation Act envisaged, if you like, a separation of distribution from trading. So in which case, distribution should have just been about infrastructure and should be focused on infrastructure. And therefore, for the infrastructure investments and the actual infrastructure operations. But unfortunately, because the two, trading as well as infrastructure, is bundled into one at this stage, it's very difficult, I think, to actually distinguish for municipalities that are actually, in terms of their conditions of license, are actually making the necessary investments and are also maintaining as they're supposed to, because the service is bundled. It simply says, do you deliver electricity to your consumers? Which has got these two parts, which are very, very different parts. For instance, when we're talking about losses, there are technical losses that are associated with the infrastructure. Those, in fact, can be managed as long as one makes a proper investment, and it would be easy to monitor as well, because you would know that somebody committed to actually investing in a particular substation or whatever, or committed to be upgrading a particular distribution line and they didn't. That's very easy to police. But the problem is that you also have losses that are associated with commercial losses or non-technical losses, which go in some cases to 30, 40, 50% of the electricity that is bought. Now, conflating the two makes it extremely difficult for the regulator to actually make sure that whatever conditions have been imposed on a distributor, it would be difficult. It would to make it easy for the regulator to make sure that those conditions are met.
So I was glancing through, but I saw three things. I thought these would be conditions that would be attached to the license. One, maintain infrastructure. Two, provide new connections. And three, setting minimum service level standards and pricing. Would I be correct in saying those certainly would form part of what they would need to fulfill?
Yes, one of 20. Unfortunately, there are about 20 conditions that could be imposed. It says they may. Unfortunately, with all of that, is that we've only got 20 KPIs and two types of businesses that, I'm sure you would appreciate, Baba, that running an infrastructure business and running a retailing business or a trading business are two types of businesses. So the question is, if somebody is doing part of that, may not be doing it too well, and doing the other part, it's very difficult because those two business models are different. So yes, those are three of the possible 20 conditions that could be that are imposed, And some municipalities do well in others and do not so well on others. But I guess overall, one would then say, well, give or take, the person may have delivered because the businesses are different.
But if Parliament then comes and points and says, we have a number of challenges, they are on generation side, because for far too long we focused on the transmission side, bringing in more people into the grid, lighting more homes, but we stopped focusing on the generation side. But also, there are significant challenges now that are coming up on the electricity distribution side. One, being significant financial challenges. Two, infrastructural challenges. Does that not say to Nersa, out of the 20, maybe we should focus on these a little bit more to say, are municipalities delivering as they should on this?
We should. I guess the one part which is something where we do need to actually strengthen is that unfortunately, the way the Act is written at the moment is that if a municipality is not doing well in terms of the conditions of license, if there's a complaint, for instance, we can investigate that, and there are two possible responses by the regulator. The first one is that we can sit as a tribunal and fine that municipality. But the problem is that if you're fining, and the fine could go up as high as 10% of revenue, but if you're fining a municipality that is already bankrupt, the question is, what does that mean? The alternative which has been called on Nersa to do is that if those municipalities, because they are granted a license, if those municipalities are not fulfilling the conditions of license, their licenses should be taken away from them and given to somebody else. Unfortunately, that process is not as easy as people would think. That although Nersa grants the license, but the license can only be taken away by a court of law. That is after procedural issues. However, it still does not take away the responsibility, or it doesn't take away the right of a particular municipality to regulate power. So that is something that needs to be explored. But what you are saying makes sense. It's just that it is difficult to then say, yes, you find somebody not to be fulfilling their conditions of license. What then do you do with it? What then do you do about that?
So there are some who are saying then, therefore, this flexible regime of power distribution, I don't know how flexible it is. If you're saying constitutionally, it would still put the responsibility on municipalities. Would make that kind of task easier for you, because then you would have almost companies that are ready and willing to be distributors, where when you do revoke the license, you've got an option of who else to license, as opposed to now where it doesn't allow you to do so.
Well, the truth of the matter is that if we actually were to implement the law properly, that is, in terms of separating out distribution, which in the manner it is defined in the law, it excludes trading. If we were to separate the two, and just perhaps, for instance, just simply then say, for a distributor, you are an infrastructure company. You are responsible for the maintenance of roads, if you like, because it's basically local roads, which are roads in terms of electricity. Those are the responsibilities of the municipalities. Then we then say, if we can separate that out, I think it is possible to do a whole lot more to hold the municipalities accountable, or those distributors accountable, because the actual KPIs are very specific to an infrastructure business. So it's something that we are currently working on to see whether we can't actually we can't implement the existing law without even needing a change. That if we can implement the existing law, we should be able to then say, for the infrastructure side of the business, this is what is is actually expected of you. And in fact, whoever is trading on your infrastructure has to pay a service fee to you. And your business is clear. It's just maintaining that road. It should be easy to do. But we are still, at the moment, I guess, looking at how to best separate out this distribution or the wires business from trading. Because once we've done that, we should be able to actually fix this problem.
So we are unclear then at this particular point what structure this new distribution entity is going to take. For example, who is going to be the owner of this asset 325,000 kilometers of lower voltage line?
Well, the original EDI model envisaged that those distribution assets would then be, so whoever, for instance, if Eskom in a particular area owed, say, 20% of the distribution assets, and the municipality owned 80%, the EDI would then have been the EDI company for that particular, or the RED for that particular area, would have been owned 20% by Eskom and 80% by municipalities. But it would have been the infrastructure side of the business. So that was the original thinking. So there's nothing stopping actually that at this stage, however it is constructed, whoever owns that particular piece of wire and associated infrastructure, then is the one, even in terms of the returns, is that they are the only ones that are supposed to then earn a return on that. But the obligation for them would just be limited to then saying, because this is an infrastructure, you have got an obligation to maintain, to invest, and to ensure that it performs and maintains, it performs at particular level and has particular losses which are associated with that part. That should be possible even within the existing framework. So that's the point I'm trying to raise. But you need to separate the trading out of it, because the trading brings other issues. At the moment, it's the bundling of the two services which are a problem.
So, in essence, I'm sure you're aware of the demand side changes, but also the supply side changes that come with this unbundling, because essentially this brings in other players who are going to come into the space of generation. Now, you're going to have a situation where coal plants, solar farms, wind farms, hydrogen electricity farms, gas turbines, all these must be in sync. They must all rotate at the same kilohertz or hertz. I don't know which one it is that they use, in order for them to fit into the grid and also fit into our systems at home when we switch on. How are we going to achieve that?
Well, let's put it this way. There's a grid code. So whoever generates is really whoever generates power, they need to actually make sure that their generation talks to the rules of generation. In terms of hertz, we are a 50 hertz country, so you can't be generating at 60 like you might be generating at that. Basically, whatever is turning must be turning such that the frequency that comes out is 50 hertz. And it must be of particular, there are other things, of course, that are linked to that. So, anyway, so that I actually don't bring other technicalities on this. But the point is, there are other ancillary services that make sure that that part is satisfied. The issue here is that even if you generate, it doesn't matter what methodology you generate, you still need to transmit the power through the transmission network, which is basically transmitted at voltages higher than 132 kilovolts. And then you still need to then distribute it. And then, of course, reticulate it, which is the final link, which basically takes it into your home. But that distribution, whoever owns that network needs to be paid a fee for the use of that system. So we've got a use of system charges. But, of course, it would be useful if those were above board clear numbers that anybody who actually invests in any generator, it doesn't matter where the generator is, knows how much they need to pay in terms of transmission and how much they need to pay in terms of distribution. But the wire side of the business should basically all, comply also with their respective grid codes, because we are governed by codes, which are basic standards.
Still on that. So we've got 325 kilometers. You look at New Zealand, they've got 150,000 kilometers. You look at the UK, they've got 800,000 kilometers. The sense is that we need to increase our asset as far as that is concerned, because of the changes on the supply side, with more players wanting to come in and fit into the grid, and with some of the changes that are being made at the generation side of things at Eskom. Who is going to extend that network?
Look, the beauty with the infrastructure side of the business, as long as it's separated off from trading, is that because it's a long-term business, 25 years, 40 years, you have, and also it's a predictable side of it, in the sense that it's irrespective of whoever generates power, it still needs to be conveyed through a system. So that generally presents opportunities for those investors who like, for instance, pension funds, for those investors who like those types of assets. But of course, you need to make sure that the risk that is associated with that infrastructure talks to the types of returns that these particular type of investors are looking for. And also, you basically need to mitigate that risk. So ideally, on anything, you should be able to project finance. And project finance basically simply says, as long as you've got an off-taker who can guarantee you an off-take of 20 years and be able to mitigate a lot of the risk, you get lots of possible funding options of that. So that's the issue. But it's only in respect of infrastructure. The challenge in South Africa is that we tend to then mix, as I've been trying to indicate, we tend to then mix the trading with the infrastructure, and unfortunately the risk profiles of those two businesses are extremely different, and therefore it becomes extremely difficult to fund. I'm talking about private funders. Mm-hmm. By the way, private funding does not mean they will then end up owning that infrastructure. They will build it, operate it, and maintain it, and then transfer back to whoever is the rightful owner of that. Of course, during the time when they are operating, they'll be getting a return in terms of the monies that they would have invested. So what that will do, it will release the burden on National Treasury to be able to fund this. So that's a possibility.
Bob, we're out of time. Of course, we could go on further, but unfortunately, let's leave it there for tonight. I appreciate you as always. Thank you very much for coming on. That's Nhlanhla Gumede speaking on behalf of Nersa.